The people of this state of Michigan versus Rock, King, and Vanderwood. Counsel, you can do cross-examination.
Thank you, Judge. Good afternoon, Mr. Schock.
Good afternoon, sir.
My name is Derek Wilczynski. I represent Stanley Road. I think you knew that. So you've been here the whole preliminary exam, right?
Yes, sir.
All right. You cover some preliminary matters first. Where were you a police officer for, what was it, 19 years or so?
No, it's more than that. So Meridian Township, I worked in Beverly Hills Public Safety for.
Beverly Hills, Michigan?
Yes.
So Oakland County.
Yes, sir.
And where's Meridian Township?
It's right here in England County.
How many years total were you a police officer?
6 years.
You were a police officer at the time that this, in December of 2020, correct?
Yes, sir.
At the time of the events giving rise to this prosecution?
Yes.
All right. Is it safe to say that when you were a police officer, you had never encountered a prosecution like this involving, election fraud?
Objection, relevance. What's the relevance?
Well, Judge, I'm trying to get some background on the witness with respect to his, what he's investigated in the past.
I'll allow it. That's the rule.
I have not handled the election fraud case, if that's what you're asking.
You haven't handled anything substantially similar to this case, right? Prior to being assigned this case at the AG's office?
Yes.
All right. And is it safe to say that back in 2020, when you were a police officer, you didn't know the ins and outs of election law as it pertains to the election and selection of electors, correct?
Yes.
And you first learned about how an elector is elected and then ultimately selected to the Electoral College from investigating in this case, right?
Yes.
In December of 2020, faced with the same set of facts as we have here, would you have known what the election laws require of electors?
Objection, relevance. What's the relevance?
I'm sorry?
What is the relevance?
Oh, Judge, this goes back to the knowledge that the electors had, what Mr. Renner, in fact, testified to. And in fact, what Mr. Brader testified to as well, is in terms of the common knowledge of the election process and how electors are selected.
How's their knowledge? Has anything to do with his experience?
Well, it all ties together because he had prosecuted them and this is a specific intent crime, not a general intent crime.
Okay. Well, what he did or did not know in 2020 before he was even assigned to investigate this case is not relevant.
No, I think it is relevant because he's in the same position at that point as all of our clients were, not just the 3 that are here, but the other 13.
I can't.
Well,
That
I
assumes
can't-
facts, not in evidence. Yeah, I can't say that he's in any position anyone else was in. I don't know what position your clients were in, and I can't say what position he was in. I'm trying to understand what the relevance. Your last question is, and I don't think that it has any bearing on what position any of the co-defendants were in. And you asking him that is not going to then place any of the co-defendants in the same position just because he gives that answer.
Yeah, I'll rephrase it, the question. I'll ask it a different way. You would agree with me, Mr. Schock, that Michigan election law, in particular how it pertains to electors, is not something that's intuitive, right? It's something that you have to actually read, get the process down and learn.
Yes.
All right. In other words, we know to go vote, we go to the voting booth, we vote as we're directed to do, and that vote somehow gets tabulated, right?
Yes.
And we sort of learn that through watching TV. We can read up on it if we wanted to, but we learn that through a general process of our everyday existence, right?
I can't speak to everyone how they learn that, but
Right.
that's how I learned.
Right. Now, election law is different as it pertains to electors. It's more complicated. You'd agree with me?
Complicated than what?
Just like we talked about before, you learning how to vote, going to vote. That was relatively easy to understand, right?
Yes.
By comparison, election law, because it's a series of procedures in a certain order, takes some education, right?
I think if you read it, I mean, I don't necessarily think you need high level of education to read it. As long as you can read it, understand, comprehend,
Right, and I didn't say that it took a high level of education. What I'm saying is, it is a orderly, let me rephrase it, it's an
Okay.
orderly system, right?
Yes,
And it requires you to have some knowledge about what some of the terms mean, right?
yes,
So for example, you had to learn what an elector was in this case, right?
yes,
Specifically, not in terms of generally what you might have seen on TV. We hear the term elector on TV, right?
yes,
But in this case, you had to learn specifically what an elector was, right?
yes.
And again, it's not something that was counterintuitive to you. Or let me rephrase
Yeah,
it. It wasn't something that was intuitive to you, that you naturally understood.
Yes.
Okay. All right, very good. Now, one thing I don't think we've covered, and this is probably more informational, but I do have my curiosity pique. Exhibit 5 was the amended certificate of ascertainment. Do you recall that?
Yes.
I don't know that we've ever covered in this case why it was amended. Do you know?
Yes, I don't want to explain it without getting it accurate.
Sure.
It had a certificate with somebody's name. So there was, I believe there was a spelling issue on it.
Just correcting an error.
Yes, correcting an error.
Okay, that's fine. With respect to Exhibit 9, that was the Republican electors. You had indicated, Ms. Logan had asked you to compare Exhibit 9 and Exhibit 11. Remember that?
Okay. I vaguely remember it, but I don't remember. Could you refresh my memory?
Yeah.
Exhibit 11 is the 2020 certificate of vote.
That's right.
I can't remember what Exhibit 9
9 was the list of Republican electors.
Okay.
All right. And you had indicated, she'd asked you to identify the differences, and you had said that there were 2 names that were different.
Yes.
Okay. There wasn't any actual significance in those 2 names other than Mr. Renner and Mr. Thompson became defendants in this case later.
Yes.
Right. There was no other significance to you. Right.
No, just the names were different.
That's right. And I just wanted to make sure of that. So, okay. Now, with respect to remember you were asked a series of questions about the US Senate and the National Archives receiving Exhibit 11 by US mail?
Yes.
Okay. You were asked by Ms. Logan what the evidence suggested with respect to who mailed the documents. Recall that?
Yes.
And you testified that the evidence suggested that Sean Flynn had mailed it.
No, I said I later learned
Yeah.
that the evidence suggested that
Right.
Sean Flynn,
Right.
but not just, it wasn't just the documents. When the documents were sent, I think there was a line of questioning before that. But anyway, to answer your question, eventually, yes, I learned that
Right.
the evidence.
And I didn't put a date qualifier on my question. At some point, you testified that at some point, the evidence suggested Sean Flynn mailed those documents.
Yes.
Okay, what we never covered was what evidence. What evidence was there to lead you to conclude that Sean Flynn had sent those documents?
There was a series of emails between Sean Flynn and Ken Chesbrough, and there were some others that were included on those emails. And then there was information that we learned that Sean Flynn had text messaged Kathy Burden or messaged her asking for permission to use her address on the envelope. So I didn't physically have Sean Flynn. I said there was evidence to suggest, so I don't have video of him actually at the counter.
Right, I understand that.
Oh.
There was circumstantial evidence that you put together that led you to conclude that Sean Flynn had mailed these documents.
Yes.
And that evidence was emails between Flynn and Chesbrough?
Yes, and others.
And others. Who were the others?
I would have to look at the emails. I don't remember.
Not my client, Mr. Grove.
No.
Okay. And then there was, what kind of a message was it from Mr. Flynn to Ms. Burden? Direct message, text
I
message?
believe it was a text message.
Text message?
Yes.
All right, now I want to turn to the issue regarding the publishing of Exhibit 11. Do you recall that?
Yes,
And you had testified, and correct me if I'm wrong, that the efforts to publish were taking it to the Capitol, and then what else?
send it to the National Archives and the US Senate.
Okay, I had heard it earlier as that it was trying to walk it to the Capitol and then sending it to Vice President Pence was on the 5th and the 6th. So it's also the mailing to the National Archives and the Senate?
Yes, yes, in addition to the mailing and walking to the Capitol, yes,
Okay,
there was an effort to hand deliver it.
to Vice President Pence.
Yes,
Who attempted to hand deliver it to Vice President Pence?
so a couple of aides for was a Pennsylvania, I believe it was a Pennsylvania senator,
Okay,
a couple of aides. Trying to think of the names.
well, let's take this one by one. Not my client, not
No.
Mr. Grove, not Mr. King.
To hand deliver it? Are you
Right.
talking about hand delivery?
Right.
To the president of the Senate?
No, we're talking about Vice President Pence, right?
Or, yeah, that's what I mean. Vice
Well,
President Pence?
I guess he is the
No,
president.
no,
of the Senate.
yes,
Not Mr. King.
No.
And not Mr. Vanderwood.
no,
Okay. The attempt to have these delivered to the National Archives and to the Senate. Again, not my client, Mr. Grove,
correct,
not Mr. King,
correct,
and not Mr. Vanderwood.
yes,
Okay. The attempts to publish it by walking it to the Capitol. Okay, I want to talk about that for a second. That was not successful, right?
yes,
Correct?
you're correct.
Yeah, okay.
Yeah,
It gets stuck in the transcript.
I understand,
It's not
yes.
gonna look good. Okay. So there wasn't an actual publication at the Senate because Captain Green did not take the envelope that he was requested to take, correct?
Could you repeat that? There wasn't a,
Right, there could not have been a publication at the Senate because Captain Green did not take the envelope that he was given and take it to the Senate, correct?
yes, it was an attempt.
And he didn't allow access to the chamber by the electors who walked it over, correct?
Yes,
And in any event, my client was not part of that convoy to the Senate, correct? Or to the Capitol? Mr. Grove,
yes,
correct?
yes, correct. That's
Okay, no, listen, it's okay.
Yeah.
I'm not trying to be smart aleck or anything like that. I just
understand.
want to make sure the record reads
Yeah.
right. And Mr. Vanderwood was not part of that convoy to take it to the Senate, correct?
Correct,
Or to the Capitol, correct?
correct.
Okay, so with respect to the publishing of this, my client and Mr. Vanderwood were not part of any of the attempts to publish, correct?
Yes, but a further explanation would be that if this was discussed in the meeting in the basement, the fact that they, as Mr. Renner had said, they were gonna plan to walk it over to the Capitol building.
Okay, well, let's take these step by step.
Oh, okay,
Okay, so there were no discussions in the basement, and you heard Mr. Renner's testimony, and there's no other discussions that you're aware of from any other witness that sending this document to Mike Pence or having it hand delivered to Mike Pence was ever discussed, correct?
yes, correct,
Okay, and there were no discussions in the basement about mailing this document to the National Archives of the US Senate.
correct,
From all of the testimony that I've heard so far, these ideas to walk it over to Mike Pence's office, to mail it to the National Archives, and to mail it to the Senate, all occurred separate and distinct from that meeting in the basement of the Republican Party headquarters on December 14th, right?
yes,
Okay. With respect to walking it to the Capitol, refresh my recollection as to what you believe Mr. Renner said the agreement was.
what agreement?
Well, you had said that there was an agreement in the basement at the meeting
Oh,
to walk it to the or to walk it over to the Capitol. Let me be more specific on my questions. I don't recall Mr. Renner ever saying that there was an agreement to walk it over, correct?
Yes, it was a poor choice of words. So it was discussed, not necessarily an agreement. It was
And
discussed about walking it over.
Let me be a little bit finer on it. I think that what Mr. Renner said was that everybody was told that this document was going to be walked over to the Capitol.
Yes,
In other words, there was no debate on it, right?
thought he said that there was discussion about it, but I don't remember specifically.
And you might remember it differently than I do, because I thought he had just said that what he referred to as the ladies that were involved in this just said they were gonna walk it over. Does that refresh your recollection at all?
It does not, I'm sorry.
Fair enough. The record will reflect what it reflects. Okay, now. There was some questioning that you had, and Ms. Logan and I had a long exchange. One of my objections, which the judge sought to see otherwise, from my perspective on it, with respect to the documents, and as this was Exhibit 28, so this was that document that you need to see a copy of it.
Yeah, that would help. There was a lot of exhibits.
Yeah, no, that's fair. And look, there are a lot. So,
Oh, wait, I remember it now.
okay, so you received some, you can hold on to it for a second. You received a lot of questions from Ms. Logan with respect to whether this document was in the basement of the Republican headquarters. Remember that?
Yes,
And you had said that you had learned that it was presented at the 12/14/20 meeting. Remember that?
yes,
And that's when I objected, and we went back and forth for a bit as to, I said, what was meant by presented. This could only come from hearsay evidence. What we never got around to was, what did you mean by it was presented at the 12/14 meeting?
I know that it was presented to Troy Hudson through an email.
Okay,
So
well, let's be
Yeah.
more specific. So transmitted by email to Troy Hudson.
transmitted by email to Troy Hudson. I don't recall, based on my interview with him, I'd have to go back and look through the report to what he says, how it left Troy and where it went to from there.
Okay, so to put a finer point on it, you don't know, as we sit here today, whether that email was printed out and left on tables at the meeting. Right?
No, I don't.
You don't know that, correct?
Correct.
All right, you don't know if it was printed out by Troy Hudson and given to anybody at the meeting, hand delivered to them.
I think my report would probably shed some light on that, but I don't recall.
Okay. As we sit here today, that was my question. You don't know if the attachment to the email that Troy Hudson allegedly received ever got out of the hands of Troy Hudson.
No, I later learned it did.
Okay, in what way?
That I received, so Troy, through his attorney, presented me with a blank document. So then I later learned, after our proffer with Mrs. Burton's attorneys, that there was a signed copy, a
Right.
signed notarized copy as well. So obviously it left.
Well, I'm asking a different question though, because that copy from Ms. Burton could have come from a different source, right?
Yes,
Okay, so what I'm asking specifically is this. You had testified earlier that this email was sent to Troy Hudson and that it contained Exhibit 28 in the email,
yes.
okay? What I'm asking is there any evidence you have that Exhibit 28 as an attachment to Troy Hudson's email ever made it to the 12/14/20 meeting?
Again, I would have to refer to my report, but I don't recall.
Okay, you don't know, as we sit here today, if that document ever made it to the meeting.
That's correct.
At some point, you received a copy from Kathy Burton's attorney
Yes,
on a proffer, and that was a signed copy.
yes.
Okay, but not that copy that was blank.
No, it was signed.
Right, and you don't know if the copy that Kathy Burton eventually signed came from Troy Hudson's email, came from Kathy Burton's email, or came from Ken Chesbro's email.
Yes,
Right.
I don't, again, my report may reflect the sequence of events, but no, to answer your question, I don't.
Okay. All right, now. With regard to, Ms. Logan asked you some questions about evidence regarding the intent to defraud, and I got really confused there because what I heard you say was that you learned about the intent to defraud through social media posts, as well as the effort to deliver the Exhibit 11 to Vice President Pence on January 5th and 26th. Now, I may have misheard you. Wouldn't be the first time I did that. So can you explain where the intent to defraud came from?
So the intent to defraud came from, there was social media posts. In fact, I know Ms. Sean Maddock had a social media post indicating that we're not electors, and I can't recall who that was sent to or from, or there was an exchange here indicating we're not electors.
When was that sent? You don't know.
I don't recall.
It's not in evidence in this case, right?
It maybe.
We've been here for 2 days.
Oh, in this particular one, no, I'm sorry. I was thinking
Fair enough.
in other
Let
sessions.
me kind of cut to the chase on this. None of these social media posts include my client's handbook, right?
No,
And none of them include Mr. Van Der Leer.
no.
And none of them include Mr. King, as far as you can recall.
The social media posts that I'm talking about, no.
Yeah, okay. What other evidence is there of the intent to defraud other than these social media posts?
Well, there's the meeting of the electors, right? So the meeting was called where these these people had a few days' notice to come to Lansing to meet at the GOP headquarters. It was, nobody else was allowed in except for specific guests, the electors, and a couple other, or a few other specific guests.
You know,
Cell
let
phone-
me stop you there. You know why that was?
Well, they said that it was COVID, but as we learned in the investigation, it wasn't necessarily COVID. They didn't want any witnesses
Okay, and how did you learn that during the investigation?
through the GOP workers.
Okay,
I think it
Laura
was-
Cox in fact had COVID, right?
She did, and she wasn't there.
And she wasn't there, but she had been in the building the day before.
Yes, but there was no masks because we questioned a little bit deeper on that. If it was COVID, who was wearing masks? And nobody said nobody was wearing masks.
Okay, go ahead. So pick this up. So what else was there with regard to the intent to defraud?
So the fact that it was in the basement, it was cell phones were taken, people were kept out. And so, again, you're also calling 16 people to meet at the same time, at the same place, to sign the same document. So all that is what led me to believe that there was intent to defraud. And also, obviously, them leaving there and then trying to serve it at the Capitol.
Okay, so tell me what you believe intent to defraud means.
Just what you said, it's intent to defraud. So intending to defraud somebody is producing a document or producing something that you proclaim is legitimate, but it's not legitimate. It's fraudulent. And as a result of that, the person may accept it as a legitimate document, therefore the intent to defraud.
Okay, you understand that in Michigan, the Court of Appeals has defined intent to defraud as intent to deceive or cheat. You understand that?
I do now.
Okay. Tell me, what about this process, about the signing of Exhibit 11 indicates an intent to deceive anybody?
Yeah, and I believe witnesses answered that question.
He is, and he's given us a roundabout answer without even knowing the definition of defraud.
I believe he gave a very specific answer of what evidence he thought pointed to an intent to defraud.
I agree that he's given his answer of what he believes, pointing to an intent to defraud. Now, based on the fact that you now explained to him where the definition could be, I will allow you to ask if that furthers or broadens what he found, but he's
Right. What about Exhibit 11? And specifically pages 2 and 3. So, well, let's go through that. I'm sure you did. Right. Oh, let's cover something real quick with respect to Exhibit 11. See page 1 where it says memorandum on the top?
Yes.
There's no evidence that you came across in your investigation that the memorandum was ever presented to the electors on December 14th, correct?
Correct.
All right, why don't you flip to the next page? You there?
Yes, sir.
Okay. You were here when I asked Mr. Brader questions about this page, correct?
Yes,
And there's nothing in that document that commands anybody at the Michigan legislature to do anything, correct?
correct.
There's nothing that directs anybody, commands it. I'm gonna combine all these, and if you want to separate them out, you can. There's nothing that orders, commands, directs anybody from the Michigan legislature, from the US Senate, from Mike Pence's office to actually do anything, correct?
Yes.
All right, that document is largely, I used the phrase yesterday, informational only, correct? Whether you agree that the information is correct or not, it's true that that document itself just has information in it. It's just information,
Yes.
right? And that information, for the most part, and I get there's some other things in there too, but for the most part says that the Republican electors have selected Donald Trump and Mike Pence as their presidential and vice presidential candidate, right?
Could you repeat that? I'm sorry.
Yep, no problem. That largely, the substance of that, the operational portion of that document are that the Republican electors have selected Donald Trump and Mike Pence as the president and the vice president, right?
Yes,
Right, and there's nothing untrue about that statement, that these electors wanted those individuals to be president and vice president, correct?
correct.
All right, now, with respect to your review of Michigan election law, which you learned after you were assigned to this case, Michigan has either a faithful or faithless electors law, indicating that if you are an elector, you are obligated to cast your electoral vote for the person from your party who receives the most votes, correct?
Correct.
And what is the consequence if you don't do that? You remember? I'll help you
That
out.
you would be, you resign.
You're removed as
Yeah,
an elector,
yeah,
right?
yeah.
And it's automatic, isn't it?
Yes,
Under that election law, none of the other electors get to vote on it and say, no, we're okay with that. We're okay with, for example, Stanley Grote voting for George W. Bush. That can't happen, right?
correct.
Right, okay. Now, with respect to that document, you heard Mr. Renner's testimony earlier, correct?
Yes,
And he indicated that it was his understanding and that it was communicated to him that the document that you're holding is Exhibit 11 was an alternate slate of electors.
Yeah, and I'm gonna have to object. It's improper to ask a witness to comment on the witness's testimony.
Not objection, she can comment all the time. I'm asking him to interpret, not even interpret, I'm asking him first off, if he just understood that that's what Mr. Renner said.
Do you want,
All I'm asking is for his confirmation that Mr. Renner testified to that.
but why,
That he
do we
recalls
need-
it.
what is this, why would his confirmation be needed? How is that appropriate?
No,
The
I'm not asking him
testimony
to.
that was given by Mr. Renner was for the purposes of the court.
Right.
Not for him to, we don't need him to
No,
interpret or.
I understand.
confirm
I'm
that.
asking him for a different purpose. All I'm asking him right now is if he remembers Mr. Renner testifying to that.
For what purposes are we asking him that?
I'm asking him if he recalls that, and Mr. Renner testifying that this was an alternate slate of electors.
I understand the question, but I want to know why.
I have to get to I'm formulating the follow-up, Judge, in my head, actually a question early as I'm doing this. I'm going to ask him if that shows an intent to defraud. Well, first off, I'm going to ask him if he has any reason to disbelieve what Mr. Renner testified to, and then ask him, depending on his answer, if that shows any intent to defraud.
Okay, as to whether or not he believes any portions of Mr. Renner's testimony would show in his position an intent to defraud, I think is appropriate.
Right.
The question for him to interpret, or
I'm not asking him to interpret.
he doesn't need to respond to that.
Let me rephrase my question. You recall Mr. Renner's testimony yesterday, where he or earlier today, where he testified that he viewed Exhibit 11, pages 2 and 3, as an alternate slate of electors. You recall that testimony?
yes,
Okay. And as part of that testimony, he also indicated that he did not have an intent to defraud because this was an alternate slate of electors. You remember that?
Yeah.
All right. Given Mr. Renner's testimony, isn't it reasonable to conclude that at least some of the electors, if they are consistent with Mr. Renner, did not have an intent to defraud?
Objection, that assumes facts not in evidence.
Well, it's a hypothetical. I'm allowed to ask.
Well,
a
and it's
hypothetical.
speculation.
That's what I thought the objection was gonna be in the first place. I agree, it causes speculation.
Do you have any reason to disbelieve that Mr. Renner was telling the truth when he testified earlier today?
Do I believe he was lying? Is that what you're asking?
Well, I was being more gracious to
Okay,
him. you
okay.
know. No, let me ask you to this, with respect to the issues that I was just talking about, okay? With regard to Mr. Renner's understanding as to the purpose of Exhibit 11, pages 2 and 3. Do you have any reason to believe he wasn't being truthful?
No.
With respect to Exhibit 11, I believe you testified on direct examination that Mr. Chesborough created the initial doc, and I'm summarizing a few minutes of testimony, okay? That Mr. Chesborough created the initial document, and then was it Ms. Burden or Ms. Sheridan that then modified it?
Well, I haven't been able to identify who modified it. All I can say is that it's been modified. So
Okay,
I know that Mr. Chesborough created it through our interview.
okay. Started out with Mr. Chesborough,
Yes,
not with Mr. Grote,
no,
not with Mr. King,
no,
not with Mr. Vanderwood.
no,
Okay, there's no evidence that you know of that either Mr. Grote, Mr. King, or Mr. Vanderwood modified that document in any way,
no,
altered that document in any way,
no,
reviewed the document in any way before it was finalized.
no.
And with respect to the first page of it, I think it's Exhibit 11, that memorandum.
Yes,
I don't think I asked this for you. If I did, I apologize. I don't mean to double up on it. There's no evidence that you're aware of that my client, Mr. Grote, Mr. King, or Mr. Vanderwood ever saw that document at any point in time. Hey, just page 1.
no,
Okay, correct? That's correct?
correct.
Okay, no, it's fine. All right. There was some testimony that you were asked about right toward the end, in which you were asked about social media messaging between or involving, strike that, involving Mr. King, Mr. Grote, and Mr. Vanderwood. You remember that?
Yes,
And you had referenced a November 15th, some type of communication in which they indicated that Jocelyn Benson was about to certify the election.
yes,
Do you recall that?
yes.
Like, let's drill down on that a bit more. What sort of social media communication were you referring to here?
I believe that was the Meta return, so Facebook.
So Facebook, okay. And what do you recall? I don't recall anything specific. What specifically was my client involved in regarding this?
I'm not sure what you're asking.
Okay. Help me out with this because I don't use Facebook a whole lot
Yeah.
myself. You know, for various reasons, right? But it has an instant messenger with it. Were they using the instant messenger portion? Were they just posting on Facebook and then commenting on each other? How was this communicated?
It appeared to be a post.
Okay. And
So
who
what-
generated the post?
They call them unified messages. I'd have to go back and look at the,
As we sit here today, though, you don't know what role Mr. Grote played in any of this. This
No.
messaging around November 15th. Correct?
yes, that messaging, yes.
And as far as you know, the only messaging that you think Mr. Grote could even have been involved in remotely was this messaging around 11:15, correct? You didn't find anything else relating to Mr. Grote,
No.
right?
Correct.
correct? Okay, and the messaging that you're talking about here had nothing to do with electors for the 2020 election, correct?
Correct.
Just had to do sort of factually that it looked something along the lines of it looking like Ms. Benson was going to certify the election.
Yes, it's more of a, there's through social media, there's posts that are shared and there's messages that are shared. It's kind of like spam, I guess, that they're generated and then they're shared amongst the groups that you may belong to or shared amongst group members. So that's probably the best way I can describe it. It's kind of like just a junk mail type thing that comes through, but it
Okay.
comes through to your account. So it's posted to your account or shared, or you may share it to somebody else's account, but it's just messaging, I guess.
You're not claiming that these messages had anything to do with the case that we're here for today specifically, are you?
No, sir.
All right, now, oh. All right, now, let me do a few other things here. You prepared the affidavit in support of all the complaints, correct?
Yes, sir.
My understanding that you only wrote like the first 30 or so paragraphs, is that correct?
Yes, I didn't write beyond I didn't write the charges, include those charges.
Who did?
I don't recall. It would have been one of our assistant attorney generals,
Okay, and why didn't you write them? Why did somebody else do them?
because that's typically how we handle things. I mean, they're the ones that are recommending the charges. So it's not something that, even if we're focusing on a specific crime and then they review all the facts of the case and then they may add or delete charges, that's not uncommon.
Your name's on the warrant though, right?
Yes.
Isn't it important to you to know who finished writing the warrant that you swore to?
I just said I don't recall.
Okay,
So
so how did you find out?
how would I find out?
Yeah.
I would probably have to go back through the case file and
Okay.
look for it.
All right, I'm gonna hand you, I'm not gonna have this marked as an exhibit, but this is the felony summons. Do you see this?
Yeah.
Did you prepare this? Or did you, and I don't mean, did you type all of this yourself?
No,
But what I'm asking for is, did you prepare each of the charges?
no,
Were you consulted with respect to the charges?
yes,
Because here's what I don't understand. For example, the first charge is conspiracy to commit forgery. You see that, right?
yes,
And I understand that. But then counts 2 and 3 appear to me that they're identical charges of forgery. You see that?
yes.
But there's no references to why there are 2 charges here. You're following me?
Yes, I follow.
So why are there, so I'm asking you the question, why are there 2 charges?
So you have I guess you have 2 votes, right? One for president and one for vice president.
I don't
So
know.
that would be the 2 different charges.
Why doesn't it say that?
I didn't prepare the document. I don't know.
Okay, so that's what the 2 counts of forgery, one for president, one for vice president,
Yes,
even though they're both contained in the same document.
yes,
All right, how do we explain, because both charges say that the defendant did falsely make, and I'm gonna just read this, taking out the language that doesn't apply to our case, but did falsely make a public record with intent to injure or defraud, right?
yes,
It doesn't differentiate between president or vice president, but B, even if it did, it'd still be one count of forgery, right? It's one document.
yes, it's one document.
Okay, so we really should only have one count of forgery, right?
Well, I can't agree with you there because I don't make,
'Cause you didn't
I didn't make the document. So,
Okay, but the intent was one for vice president, one for president.
yes,
All right, now. If I'm following your logic now, let's see if I could pick up on this, okay? Count 7 and 8, which appear to be the exact same charges of election law forgery. See that?
yes, yes,
I'm presuming it's the same logic here, one for
Yes.
president, one for vice president,
yes,
correct? Even though it's in the same document.
yes.
Now, with respect to And with respect to all of these charges, all of these require the document to be false, correct?
Yes.
All right. Have you looked into at all what makes up a false document in Michigan as decided by the Court of Appeals?
As decided by the Court of Appeals now.
Right, okay. I would submit to you that the Court of Appeals has determined that the maker of the document must have knowledge that the document itself was false. Okay, so given my next few questions are going to rely on that, okay, that the maker of the document must have knowledge that it was false. Take your time, you need to pick it up, go ahead. Sorry about that.
Okay.
Everybody's got water these days. We're all overhydrated.
Yeah.
So, okay, now, let's go through this. The document in question was made by one person, right? Or Chesbrough, or maybe two, Chesbrough, and then altered by somebody else, right?
Well, it was Chesbrough, and I couldn't recall the other person that contributed to drafting the document.
I understand.
And then that version was altered once it was received by Marion Sheridan. It was then altered again to People's Exhibit 11.
There's no question now that the defendants in this exam, that there's no evidence. Let me ask this a different way. There's no question in your mind that there's no evidence that the defendants here made that document, right?
That's a lot.
Yeah, let me rephrase. I'm withdrawing that question. I'm going to rephrase it. Okay, there's no evidence that any of the defendants for this exam made the document and it was in Exhibit 11, right?
Right.
Okay. And there's no evidence in this case that any of the defendants here had knowledge that that document was false, correct?
When you say here, you mean in this
In
setting?
this exam, Judge.
Okay, thank you.
Yeah, sorry. I keep saying King, Vanderwood, and Grote, and after a while it gets
Right, I
repetitive.
just wanted to be clear for myself.
Could you repeat that question?
Yeah, yeah.
As I'm thinking about it, I mean.
We've already determined, you've already agreed that they didn't make the document.
Right.
Okay. And there's no evidence that either Mr. King, Mr. Grote, Mr. Vanderwood knew that the document was false, affirmatively knew that it was false.
Well,
Here,
I can't say that they would know that it's a legitimate document.
No.
So,
Let me back up. I'm asking you, let me withdraw. I'm going to ask you a
Okay.
different question. Okay. You understand the difference in the law between having actual knowledge of something or a different but similar concept of should have known, right?
yes,
You know, I didn't know this was the case, but I should have known it. We apply that in civil law an awful lot, not as much in criminal law. Okay. You understand the difference between those concepts. Okay. With respect to affirmative knowledge, you know, the actual knowledge that somebody knew, there's no evidence in this case that either Mr. Grote, Mr. King, or Mr. Vanderwood knew about any potential falsities of Exhibit 11, is there?
well, I would say that based on Mr. Grote's and Mr. Vanderwood's experience in elections, especially Mr. Grote's, that he would have knowledge that this isn't a legitimate document because he would be familiar with the electoral process.
Okay, I didn't ask you that though. So you're saying he should have known, right?
Yeah.
Okay, I'm asking you a different question.
Okay. I thought
The
that's
question
what
I'm
you were
asking you
me.
is there any affirmative evidence in admission? You seeing him on video saying, yeah, we fooled the ball or something like that, or any type of firsthand knowledge that you had that he affirmatively knew that this document was false, right?
Correct.
And there's no evidence in this case of that, right?
Yes.
So your methodology to concluding that Mr. Grote knew or should have known that this document was false was based on his position as a clerk.
Yes, his position as a clerk, his experience in elections as
Okay,
well. Also the fact that, I mean, it's not just him, it's the fact that, you know, the Board of Canvassers had already certified the election. And,
Okay.
and so there was a certification. None of these people were invited to Lansing to sign the certificate of votes, and there was no recount and stuff. So all of that, it's more of the totality of the circumstances, which led me to believe that all of them would know that this is not a legitimate document.
Okay,
I mean, there's,
well, I didn't ask you about a legitimate document. I asked you whether the document was false.
or
in
a
any
false
way.
document.
Those are two different concepts. You
Okay.
understand that, right?
I perhaps maybe used the wrong word, but
That's
false,
fair.
a false document.
That's
Okay.
fair. Okay, so let's go through, I'd like you to turn back to Exhibit 11, and I'm almost done, okay?
Yes, I'm there.
Okay, on Elizabeth 11, Exhibit 11, tell me what it is about that document that's false.
Page 2, duly elected and qualified electors convened and organized in the state capitol, in the city of Lansing at 2 p.m. That didn't happen.
Okay,
On the
well, they were
14th
in the city of Lansing, weren't they?
of December. Yes.
And
Yeah.
it was December 14th,
Yes. Yeah.
and they tried to get it in at 2 p.m., right?
Yes. Yeah.
Okay, it wasn't in the Capitol, right?
Yes.
All right, now, does that actually have any substance with respect to documental or Exhibit 11? In other words, does it really make a difference whether they said that it was in the Capitol or they were somewhere else? You don't know the answer to that, do you?
I think the witness should be allowed to answer.
Well, no, my question is, you don't know that, do you? You don't know if there's any significance to that, do you?
Well, the significance is that it mirrors the legitimate certificate of votes.
I'm
Is that what
asking
you're
you,
asking me?
no, I'm asking, is there any legal significance to whether
Oh.
that statement's correct or not? You don't know.
You're talking about the location?
Yes,
specifically?
Capitol, that's right. Go ahead. You don't know.
No,
Okay.
Is
Fair
that
enough.
no, you don't know, or is the answer no?
I don't know.
No, you
Okay,
don't know.
thank you.
Okay, sorry about that, Mr. Schock. Fair
That's
enough.
okay.
Okay, keep going through there. What else is incorrect about that document? Just page, we're on page 2 now. Sorry.
Oh, okay.
Sorry, yeah,
I
not the
thought you
whole-
wanted
not the
me
whole
to keep
document.
flipping
No,
through.
no.
That's
Nope.
it. So,
Okay, that's it. And again, everything else in that document was just informational. In other words, we're the Republican electors, we're casting our votes for Trump and for Pence.
yes,
Okay, now, with respect to that phrase, duly elected electors, Michigan is sort of strange in the sense that the electors are actually elected at the fall convention, right?
yes,
And you saw me ask the questions about this to Mr. Brader yesterday, right?
yes.
So they are actually elected at the fall convention. That's what the election law reads, correct?
I thought it was, I thought they were candidates.
No, we can go through it, but even Mr. Brader again, the language of the statute says they're elected at the fall,
Yes.
fall convention, right?
I'm sorry, I thought he
I'm
said
sorry, which
candidates.
statute is that?
Yeah, let's pull it out here. Do you have
I
the
thought he
statute?
said they were
I think they're
candidates.
exhibit 1.
The one
Because
that
I
I did
Exhibit
yesterday?
1, yeah.
Yeah.
No, this isn't the one I'm looking for. We can give this to him too, so. Okay, now, let me show this to you because there's 2 parts to this I want you to look at.
Okay,
So this is section 42. See
okay,
this?
yes,
And it starts out in the year in which the blah, blah, right? Each political party in the state shall choose at its fall convention, a number of electors for electors, a number of candidates for electors.
yeah,
Okay,
that's where I was pulling it from.
That's right. And you heard Mr. Brader yesterday, and he had testified that at the fall conventions, as far as he knows, at least the major parties actually elect their electors there.
I'm sorry, that's a mischaracterization. Mr. Brader testified he wasn't sure how the Republicans selected their
I don't
electors.
believe, the record will reflect what it reflects, but I believe he had testified that they're actually elected there.
I don't believe he said that.
The record will reflect what it reflects.
Thank
Okay.
you. Thank you.
All right. Now, you're with me there, right?
So that it further states. the
Well, hang on,
certi-
let's just take it part by part.
Okay.
It's a lot easier to do that.
Okay.
I will submit to you that the record will either prove it or not prove it later, that the Republican Party elects its electors at the fall convention. Do you have any reason to disagree with that?
I'm going to object because that assumes facts not in evidence.
Well, I'm asking him to assume this for the purpose of my next few questions. And we can make an offer of proof on this, before the proof.
So how the Republicans elect their
That
electors,
they're elected, yeah, that they're not selected, that they're actually elected.
if necessary, you can do an offer. of proof.
Yeah, okay. Okay, so, Mr. Schock, what I'm gonna submit to you, because Ms. Logan's right, I don't want to go back and forth as to what Mr. Brader said, but
Okay.
I will make an offer of proof to the court that the Republican Party at least, and I think the Democrats and the Libertarians and the Greens do it the same way, that they actually elect their electors at their fall convention, okay? You understand that?
Okay.
And then Mr. Brader had testified later that those electors are not elected at any point prior to that. They're then selected to be electors depending on which party gets the most votes. You understand that?
Yes.
Okay. So these electors are elected one time and then selected a second time. You with me?
This says that their candidates for electors shall
Right.
be considered elected by those who are certified to the Secretary of State by that political party receiving the greatest number of votes. So
Right.
does that answer your question?
Yes,
Okay.
exactly. That's exactly where I'm going with
Okay.
this, Mr. Schock, because this process is strange. You would agree with me, right? Where you're elected once and then just by the number of votes that turn out, you're then considered to be electors, right? You're not elected a second time.
Yeah.
The law speaks for itself and it's very clear. And I think counsel in his question is conflating it. The sentence in the last sentence of MCL 168.42 is very clear about when candidates for electors are deemed elected. Okay.
I agree. That's exactly what I'm saying, Judge.
Okay,
What I'm saying is
I don't have a copy of it for me because I think he might have a copy and the court
He
can
does.
obviously make an interpretation of what the language says. I'm trying to understand I guess the purpose of
Yeah,
what,
here,
in which
here's
you
where
have
I'm.
him making this interpretation now.
Here's where I'm going with this, Mr. Schock. You had testified earlier that you believe that the document was false
Are
or
we moving
considered.
on?
What's
Okay.
that?
Yeah, I'm trying to understand the purpose of the line of questioning as to him, because he did, as to that last question, I don't think he
Well,
answered, so you
withdraw the
withdraw
question.
it?
I'll
Okay.
withdraw that question, move on. So, you had testified earlier that you believe that the document was false because these individuals were not duly elected electors, right?
Yes.
All right, and you indicated that Mr. Grote should know that because of his position as a county clerk or a township clerk, right?
Yes.
But even looking at the language that's used there, it's relatively confusing, is it not? As to when somebody is an elector and when somebody's selected as an elector and when somebody's considered to be an elector.
I would say it's not. I mean, it says that when you're nominated by your party, as an elector, you become a candidate for elector, which is that people's exhibit, I can't remember the name, where they had all the names of the candidates for elector that were sent to the Secretary of State. And then when your party receives a popular vote and the Board of Canvassers certifies, then you become an actual elector. That's my interpretation of it.
And did you know that before you started investigating this case?
No,
You had no reason to know it, did you?
no.
What reason would a township clerk need to know that process prior to becoming an elector?
Because they handle elections for the township.
Do
So
they handle electors?
no, they don't, but
So why would Mr. Grote need to know that?
I-
Your Honor, I'd ask that the witness be allowed to finish his answer before the
Sorry,
next question.
He paused, Judge, and
I get it.
I apologize.
Thank you.
I would think, based on his background, his experience, his education in elections, that you would follow the process, you wouldn't just finish it off at your township office or your township office or municipality, but you would also follow it through because you're sending it the votes that he collects to the county sends them to the state and whatnot. So I would think that he would have knowledge of that.
Mr. Scheck, I practice criminal law and some civil defense for ambulance company. Would you expect me to know probate law?
Objection, argumentative, and not relevant.
Well, I think it's relevant, Judge. This is an entirely different area. You understand the analogy I'm
Well,
trying to
we
make.
gotta, I have to address that, unless you withdraw the question after
No,
addressing
no, go ahead.
the. Okay, you said it's relevant, why?
Because it's an analogy as to what Mr. Schock just indicated. He testified that he thought that Mr. Grote should know about the elector process simply because he's a township clerk. What I'm saying is there's differences between what a township clerk does and what an elector is, just like there's a difference between someone who practices criminal law and probate law.
The question was that the defense attorney said, I practice criminal law, and would you expect me to know this other area law? Not relevant and also argument.
I think it's
Okay,
relevant.
well,
It goes to illustrate the point by analogy, what I'm trying to make.
I think it is argumentative, so let's not do that. But I get the analogy you're trying to go. I think there's a better way to ask it.
Okay. Yeah.
And to the point, I'm glad that that question came out, because I was gonna ask, I have that question here, because he answered about Grott's prior experience. He should have known. I don't know what Grott's prior experience is, so, you can
Yeah,
rephrase your
so-
question, maybe?
I think he did. You're talking about Mr. Grote's experience as a township clerk,
As a township clerk.
the elected township clerk.
Yes, sir.
And what specifically about being elected as the township clerk? What is it that he does on a day-to-day basis where you would expect him to understand the process for an elector getting elected and then elevated to the position where they would cast their vote?
Well, they run elections for the township, so it's a combination of all that experience and education and running elections for the township. And I'm saying that you asked me for the answer, so I'm saying that yes, it's reasonable for me to believe that he would have knowledge of this process. And
But
Not only-
Sorry, go ahead.
not only that is, I know that I know we can't. Go ahead.
What
I know we can't
is
get
it-
into
what-
certain things.
I think he wasn't finished his answer. You know, you can't what?
We can't, there was a proper judge, so
Oh,
I know that I
right.
can't get into certain things, so I'm trying to just
I get
be
it.
respectful of that.
I'm being more specific here. What is it specifically about being a township clerk that you would expect Mr. Grote to take with respect to his knowledge of the election, of the elector process?
And I believe this is asked and answered.
Now, what he said was, oh, I believe he's a township clerk, so therefore he knows, and he hasn't answered anything and I'm drilling down to a more specific question here.
What specific duties as a township clerk
That's right,
does he believe
that's
would
right,
cause him to have knowledge about being an elector? Is
that's
that the
right.
question?
What duties does he undertake as a township clerk? What specific duties does he undertake that would let him know what the elector process is?
I'll allow the question.
I don't know.
Thank you. Almost done, Mr. Schock. I don't think I've told you that yet, but I try to follow my word on this. Without reading 168.42 and on, how would somebody who was elected as an elector know what it's his or her rights, duties, and responsibilities were?
Objection, speculation.
Do you want to respond to the speculation objection?
Yeah, I don't think it's speculation, Judge. I'm asking if the witness knows any sources that would tell an elector where to, what their rights, duties, and responsibilities were, other than within the statute itself. Is he aware of any publication, any training, anything?
I think that was your question, though.
It was.
But,
Well, that is my question.
well, you
now,
didn't phrase
so-
it that way. So I like the way you phrase it that way.
Fair enough. Go ahead.
I don't know.
Okay.
Does that answer it? I think you were
It does.
asking. Okay.
So you don't know of any mechanism by which somebody would know what their rights, duties, and responsibilities were of being an elector, other than what's in the statutes themselves.
Other than what's in the statutes, and if there's party conventions, there was a couple of people that I did interview that, well, a Republican who was a Republican elector some time ago, I can't remember when, Judy Rapanos that I interviewed, and then Steve Rizeppa, who was an elector after. So he was an elector in the 2020 election, and I asked them that same thing, and they said that they would get a call from somebody, their party, that they expected a call from somebody once they would become an elector for the state. So, but they didn't have a specific person.
During the course of your investigation, how did you learn what the rights, duties, and responsibilities of electors were?
By following up with the Secretary of State, figuring out, contacting the governor's office, trying to figure out, well, how were these electors notified? The legitimate electors. So the Democratic electors, how were they notified in 2020? And there was a correspondence that was sent to them through the governor's office. And then they were requested to come to Lansing on the 14th day of December 2020.
You heard the testimony of Mr. Renner today. Is there anything that he told you about how he got notified, about how the meeting was held, or about what happened that would lead you to conclude that it was illegitimate?
Was there anything that he told me?
No, that he testified to.
Okay, that he testified to. Was there anything that he testified to that
And let me walk you through it
would
step by
lead
step.
me to believe that that it was illegitimate?
Yeah, I'm gonna withdraw it. Let me walk you through it another way, and I'm almost done.
I can answer.
Go ahead.
If that's true. I mean, the fact that he was called last minute. He came to Lansing, was called by Janelle Leonard last minute, or emailed, I can't remember. I think it was an email or a phone call. Anyways, he gets to the GOP headquarters. There's a meeting in the basement. Their cell phones are taken. They're asked to sign, this document. His questions aren't answered. He doesn't, he requests a copy of the document. They won't give him a copy of the document. So all of those things,
Okay,
I would say, would lead me to believe that it's not legitimate.
all right, let's walk through this. Okay, let's take this step by step. So the first thing you said was that he received a call a couple days before the meeting. What was odd or illegitimate about that? Let's take this by its
The fact that
component parts.
the fact that he's getting a call from basically a friend of his to come to the GOP headquarters. So there's no
Well-
correspondence like from the government, the state of Michigan, saying, it's not like Governor Whitmer's office or Secretary of State Benson's office is contacting him. So that's the first thing.
Okay, well, let's back up. Let's drill down on this. The reason he got an email from a friend of his, Janelle Leonard, was to replace somebody else, right?
Yes,
And that was made pretty clear.
yes,
Right? He testified to that, right?
yes.
So there was nothing illegitimate about that, right? He was replacing somebody.
To me, it's illegitimate. Yeah, I mean, if you're replacing somebody, you're replacing somebody for what? I don't.
Well, that happens all the time, doesn't it? In politics, it happened on the.
I don't know.
Okay.
I don't know.
do
I
you?
don't know if it happens all the time.
You
in
don't know, do you?
politics.
Okay. The fact that he received an email, with the benefit of hindsight, you think that's illegitimate now, but would you have thought that at the time,
At what time?
the time that he was given the email, sent the email?
Wait, I'm sorry, I'm going to object because I'm not sure what this witness's opinion is on the legitimacy in December 20 is relevant.
He's already answered. So now I'm
Yes.
questioning him about, no, he did. He said that he thought receiving an email is illegitimate. Now I'm asking him, not with the benefit of hindsight, but at the time of the receipt of the email, what was illegitimate about it then?
No, you asked if he
thought it was illegitimate and what his opinion of that process back then would have been irrelevant at the time.
He's already testified to it. He's already said he thought it was illegitimate. So I'm
Part,
following up on what he's already testified to.
with all due respect, the initial question was as part of his investigation, what he found illegitimate, and he said, well, first of all, the last minute email.
Right.
The next question, what I'm objecting to is what his opinion would have been about receiving that email in December 2020. That's not relevant.
I think that's the only thing that's relevant, because with the benefit of hindsight, he's
Yeah.
looking back on this case now. What I'm saying is, had you received the email in 2020, what about it would have been legitimate at that time?
Had he received the email
Or
or
had Mr. Renner received the email,
in 2020?
right, at that time? When he received the email at 2020, not with the benefit of hindsight, would he still have thought that there was something illegitimate about
Who's the second he?
Yeah. That's what-
it? Mr. Renner?
Okay, so you're asking Agent Shock, if Mr. Renner had received the email in 2020, would Agent Shock have found?
He's already testified that he thought Mr. Renner's receipt of the email in 2020 was illegitimate. And I'm asking him, with the benefit of hindsight, or looking at it from the perspective of being December 12th or whatever of 2020.
How is it relevant?
Because with the benefit, we look back on cases with the benefit of hindsight all the time, can't do that. Have to look at it prospectively from the time that whatever the event is that we're judging has occurred. In Mr. Schock's case, he's saying now, and I want to differentiate, is he saying this after the fact or based on where these people's position was as of, say, December 12th of 2020, how we're looking at this?
You lost me. I don't know if you lost the witness.
Do you understand what I'm saying, Mr. Schock?
Yeah,
Okay,
Well, with all due respect, the entire investigation is hindsight because
course.
Investigator Shock was not there.
that's
You
right.
cannot put him in the position of receiving that email on December 14th, 2020. It's just not a thing.
No, but I believe I can ask him about it at the time of the receipt of the email with no other facts, because there were no other facts at this point. Mr. Renner to receive the email in
You
December.
wonder if
12th.
that would have changed, if that would have
Yeah.
changed his investigation? Is that
No, what I want to know is if he named a number of different things that in
Correct.
combination led him to conclude that this was illegitimate.
Yes.
This meeting was illegitimate. I'm taking them component by component. So I asked him, what is it about this email that he thought was odd? And he had said, well, it was an email to replace somebody. It was 2 days before the event. And what I want to know is what's odd about this email. I want him to look at it from the perspective of James Renner in December of 2020 and not going back and looking at it in combination with everything.
So you want to know if it was odd about the emails that he received the 2 days prior
Yeah.
versus receiving it?
That's right.
Well, this witness can't testify from the perspective of Mr. Renner.
He's trying to
Okay.
figure out what
Alright,
caused
let me-
him to think it was illegitimate. Is that,
You know what, let
I
me
thought
ask
that
you
was the question.
Well, the witness.
Let me
is
ask it a
answering
different way,
that
Judge. I'll
question.
withdraw the question and re-ask it.
Thank you.
So, you saw that Mr. Renner had no issue with receiving the email 2 days before the meeting, correct?
Correct.
All right, and you're saying that it was odd even though Mr. Renner didn't?
Correct.
Okay, now, what were the other factors that you had mentioned?
After that discussion, I
that's
lost
okay.
my thought.
I got you. Okay, you talked about it being
Um,
in the basement of the
yes.
headquarters. Was the fact that it was in the basement, that had some relevance to whether you thought it was legitimate or not? Where else would they have held it?
Yeah, I mean, the fact that it was in the basement coupled with, I mean,
Yeah.
there was enough room apparently on the first floor for people to gather. So it was in the basement. Like I said, people were prohibited from coming in unless you had a direct invite, cell phone.
Well, let's take this step by step, because I'm just asking you about the basement.
Okay,
So there was nothing about it, solely about it being in the basement, that was problematic to you?
what do you, I don't understand what you
It was
mean. that it's
illegitimate. I
problematic.
said problematic, let's say illegitimate. The fact that it was in the basement really held no significance, did it?
I think that it does to a certain extent, because there's no windows in a basement, so
So what?
they were concerned about privacy. And whether that's through cell phones or people taking pictures, recording it. That's what I heard from the people that I talked to.
Why
So-
would the concern about privacy be an issue for you? Wouldn't they want this to be a private meeting?
There was a discussion about it being a secret meeting. And
Okay.
so there was some people that knew about this meeting coming together. In fact, I remember listening to a recording of Representative Gary Eisen talking to a radio host about a meeting. And
Okay,
again, it was, he wouldn't let on or explain everything about it, but he had knowledge that there was going to be a meeting and things. He didn't really discuss specifics of it.
so Gary Eisen mentioned that there was a meeting and was publicizing this secret meeting, and somehow it was problematic that they held the meeting in the basement without the windows. Is there any problem with them having a secret meeting?
No, there's no problem.
It's their club, right?
Yeah,
They can have a secret meeting if they wanted.
yes.
And none of the people that you talked to, other than hearing Gary Eisen, said that it was supposed to be a secret meeting and that nobody was ever supposed to find out about it, right?
No, it was discussed amongst people that I talked to at the GOP that there was a private meeting with, like I said, only certain people that were invited, including the electors.
Yeah.
Right.
Okay,
And
all right.
they,
No, it's correct. Go ahead.
no, that's fine.
No, go ahead. Finish.
I'm done. That's all I
All
have.
right. No cell phones, you can understand that, can't you? Because they wanted to keep people away, photographs away. They didn't want it recorded,
Yes.
right? You can understand that, right? That's reasonable.
Yeah. I mean, if you don't want it recorded, yes, absolutely. You don't want cell phones in it.
What other factors? I think you had maybe one or two more. And then I promise you, Mr. Schackenbach.
I'm trying to think of the ones that I've mentioned now. I think I touched on the fact that there was security at the front door, or pseudo security. They weren't officially security guards, but they were, not letting certain people in. I think that was one of the things that I touched on. I can't remember the other.
That's okay. Last area that I need to cover with you. In paragraph 27 of your affidavit,
Okay.
you stated in here that the candidates for elector in the Michigan GOP leadership knew prior to their meeting on December 14, 2020, that there was no legal reason to create an alternate slate of electors. Remember writing that?
Yeah.
And the alternate slate of electors is consistent with what Mr. Renner testified to, right? And the sentence right before this in your paragraph says that prior to December 14, 2020, Senate Majority Leader Mike Shirkey and Speaker of the House Lee Chatfield announced there was no evidence of voter fraud sufficient to affect the results of the election, and the House and Senate would not be taking action to contest the electoral vote. You remember that?
Yeah.
You remember Ms. Logan asking Mr. Renner questions about that, right?
Yes.
And Mr. Renner had stated that he had not heard a statement from Mr. Chatfield or Mr. Shirkey. And specifically, Ms. Logan's question was that they would not be changing the vote. You remember that?
Yes.
Okay. Given Mr. Renner's testimony that he had not been made aware of this, he did not know about the statements from Mr. Chatfield or Mr. Shirkey. There's no other evidence, is there, that the candidates for electors, and specifically Mr. Renner, knew prior to the meeting on December 14th that there was no legal reason to create an alternate slate of electors?
There was no, what I meant by there's no legal reason is there was no court order directing the state to have another slate of electors. There was no recount. There was no official government entity saying, this election is in question. We need to have a recount, or you need to send a second slate of electors.
That didn't mean, though, that there couldn't be a court order, right? After December 14th.
Yes, yes.
There could have been. right?
Yes. But at the time I wrote it, that's what I meant.
No
was-
further questions.
Yeah.
Thank you.
Good afternoon, Mr. Shine.
Good afternoon, sir.
My name is Mike Smith. I represent Timothy King, one of the defendants. We had several questions for you. I'm going to start with some of your most recent testimony. Then I'm going to work relative to your affidavit.
Okay.
Mr. Schott, isn't it true that you possess no evidence that Mr. King has any knowledge or any experience that this document might be false? And that's exhibit 11.
What do you mean by that?
You indicated in your previous testimony that you believe that Mr. Grout and Mr. Vanderwood would have experience in looking at exhibit number 11. And I'm asking you, do you have any evidence that shows that Mr. King has any experience about voter elections and election law and exhibit number 11, as you stated in your previous testimony?
No.
Now, I want to take a look at your affidavit. A couple questions relative to that affidavit. You stated in your previous testimony that you didn't write the entire affidavit, correct?
Yes.
And
That's correct.
And somebody else wrote a portion of that affidavit. Is that correct?
Yes.
Was there more than one person that wrote that?
I don't know. I don't know, sir.
So when you did you meet up with the magistrate that signed the warrant? Did you meet up with her telephonically, or was it in person?
Telephonically.
And do you recall being sworn in?
Yes.
And did you fax something over to the magistrate?
I believe it was email.
And what did you email to the magistrate?
The affidavit, and then I believe these documents may have been attached as well.
You said may have been attached. You don't reference that in your affidavit that you're attaching any documents to the magistrate. You don't reference that at all. You said it may have been included. Is that what you're saying?
I don't recall.
So you don't recall if exhibit 11 was included, right?
I don't.
Okay, that's fair. Exhibit 11 is extremely important in this case. Would you agree with me?
Yes.
And would you agree with me that it needed to be attached to your affidavit to the magistrate? Would you agree with me on that?
Objection, relevance,
Okay.
Whether or not exhibit 11 needed to be attached?
the affidavit.
Yeah, what is the relevance?
The relevance of that, Your Honor, is that exhibit 11 is what we're here for today. And exhibit 11 also has the signatures, the alleged signatures of the electors. One of them has to be approved.
Why would that need to be attached to what he faxed to or provided to the?
I believe the magistrate needs to see exhibit number 11.
He absolutely does not.
And let me
We can, no, because it's 3:30, we can cut to the chase. Magistrate, we have a rotation here, so I personally know for a fact she was on the one who reviewed this, and when we're on call, we don't get exhibits when we review warrant and complaint packets. We get an affidavit of probable cause. That's it, and it's sworn. We don't get exhibits. Why would you submit exhibits to the court?
Judge, just to let you know, I used to be a magistrate back in the 80s, and we did get exhibits back then.
So 40 years later, things have changed.
Oh, Your Honor, I still think I'm very young.
Yeah, I get it, but I was born in the 80s. Things have changed
Things don't
grossly.
change. You can
We
be my
do
daughter.
not get and should not get the evidence. We are supposed to get an affidavit of probable cause. We do not review evidence to issue a warrant and complaint.
Judge, I'll move on.
Thank you.
But Judge, I just wanted to address something on the record, that affidavit, when you look at it itself, and the magistrate would have looked at it, there would have been no fraud. She would have never seen fraud. Nobody.
She's not there to make a determination of the evidence. That's what I'm here for. When you're on call, you're there to make a determination of probable cause, but it's a different standard. It's based on the sworn statement of the law enforcement and the complaint as it's pled. The person who's going to review the evidence and any exhibits, that comes at the probable cause stage. And that's what we're here for today.
All right, Judge. Mr. Schock, would you agree with me that Mr. King has no, by signing, allegedly signing exhibit number 11, would have no financial gain in assigning that?
Yes. Or correct.
Correct. Thank you, sir. Is it also true that you don't have any independent knowledge or personal knowledge that Mr. King was afforded an opportunity to look at all of exhibit number 11, with the exception of page 3 of exhibit 11, which is the, I would call it the sign-in sheet, or the one that was attested to?
Did he see more than, are you asking me, did he see more than one document? Is that what
Yes,
you're
do
asking?
you have any evidence that shows Mr. King saw page 1, page 2, page 4, page 5 of exhibit number 11?
I know that Tony Zamet, Michigan GOP employee, said that there were multiple documents on a table as your client and others were in the room. That's all the information I have for you.
Right, thank you. But my question specifically is as to Mr. King. Do you have any evidence that Mr. King saw or read any of those documents that you just described?
No.
I'm just trying not to, I'm going
I
over this
understand.
carefully because I'm not trying to repeat
No,
the
you're-
questions by counsel.
Okay, thank you.
And sir, you don't have any evidence that Mr. King specifically intended to publish exhibit 11?
Well, yes, I mean, he was with the group that walked to the Capitol that day attempting to serve it, or
So, okay, so he was with a group that walked to the Capitol on that day. I'm sure you're referencing December 14th.
December 14th with the group of electors, a Republican.
Did you hear? So he was with a group.
Yes,
So that's his specific intent in your mind to publish exhibit 11.
yeah,
So anybody that was in that group, you would say was intended to publish exhibit 11.
yes,
Okay. So that would be Dear Rendon.
yes,
Was she charged here?
no,
Objection, relevance.
Just ask the question, Judge.
Objection sustained.
So she wasn't.
Objection was sustained, so
No, I'm
that
just,
answer is stricken.
Thank you.
do you have any specific knowledge that Mr. King knew what was allegedly in that envelope that was being brought to the to the Capitol. The Senate chamber.
He's standing at the front door when Ian Norton's describing what they're trying to do and what's in the envelope.
So he was right there and he heard everything. You know for a fact that he heard everything.
That's what the video shows.
That's what the video shows.
That he's with, all I can say is that what the video shows is him being right there. Right?
Okay, so it shows that he's being
That
right
he's
there.
present.
All right. But you don't have any other specific evidence, specific intent that he knew what was in that envelope, or he knew what that attorney was trying to do.
Well, the attorney discusses it while he's there. So
And what does the
just
attorney say?
Your Honor, I've asked that the witness be allowed to complete his answers.
We want him to complete the answer.
I don't recall specifically, but he's trying to ask the state trooper to get entrance so they could serve the Republican votes. But I don't specifically what he says is I can't remember, you know, what he says.
Does he say that it's, do you recall if he said that there was an alternate slate of electors in case there was an issue with respect to the votes, or there was a court order that might be coming out? Did he say anything like that to you?
I can't recall. He may have, he was talking about, you know, why they were there, what the purpose of them being there was, but I don't remember specifically.
Is that very important that you would know what he would say? Because that's what you're alleging, that Mr. King had specific intent of what they were there for, and he was there in the crowd.
Yes.
Do you have any specific knowledge that Mr. King had specific intent by signing his name? And I'm alleging that he signed his name. I'm not admitting that he signed his name. But do you have any knowledge of Mr. King's specific intent? If he did sign that document, that he was trying to defraud somebody, in his mind, do you have any evidence of his specific intent, if he had any?
Just the signing of his name. He didn't agree to speak to me, so I don't have a statement or anything like that, and I don't have another witness that said Mr. King said this or that. Does that answer your question?
That's fair, sir. Excuse me. I can't remember one thing I wanted to start with. Mr. Schott, you indicated that you started this investigation sometime in December of 2022.
Yes.
Okay. And you retired from being a police officer, I believe you said in sometime in 2021, correct?
Yes.
But you also indicated that it was very difficult in this investigation when the occurrence that you were investigating, it happened in 2020, and you're starting your investigation in 2022 or at the end of 2022, correct?
Yes.
And you noted that, you know, tapes get erased, videos get erased, that kind of thing. However, you did indicate that there was another investigator that was investigating this before you, correct?
Yes.
And do you remember what her name was or his name was?
Yes.
And who was it?
Agent Scott Cronin.
And how long was he on this investigation before you took over?
I want to say just a few months. So I'll throw out 3 to 6 months, maybe 3 months.
And then when you took over, did he leave the investigation?
Yes.
And you know why he left the investigation?
Yeah.
Objection, relevance.
What was the relevance?
I would like to know why he left the investigation, Your Honor, because it could lead to admissible evidence. I mean, what if he were to say this? What if he were to say that? That's what I need to know. What if he said, I don't know, I don't think that there's anything here. I'm out. How else am I going to find that out with just chasing Scott Cronin down?
Well, with all due respect, the purpose of an exam is not discovery process. It's to determine whether or not the listed defendants committed a crime. It's not a fishing expedition.
I tend to differ.
You believe it's a fishing expedition?
No, I didn't say fishing
No.
expedition, Judge.
That's what she said, and you said I beg to
You
differ.
know, there's not one lawyer that would say that.
Okay.
What it is for discovery purposes. And this is why we ask these questions. If it was so important, she could have objected to him mentioning that name of Scott Cronin. That would have been irrelevant according to, to her arguments.
I can't object.
I just want to know why he stopped investigating this matter. He was about ready to tell me because he knew why.
Well, he said he knew why. I don't know if he was about to tell you, but nonetheless, I do agree that this is an evidentiary hearing. I don't believe it's a fishing expedition. To the extent that this answer, I'm assuming you want to see if there's some exculpatory evidence that comes from his next response. I'll allow him to answer it.
Thanks, Judge.
So there was a position that opened up in another unit, and Agent Cronin put in for that position, so he was transferred to that other unit. So I work in a different unit than him now, so oddly enough, when he left the unit that I'm in and went to, say, Unit B, I transferred into Unit A where he was, and that's how I was taken up. That's why I was assigned to take over his cases, which isn't uncommon.
Thank you, sir. Did he, and he transferred all his files to you, correct?
Just this case, and he doesn't.
No, I'm just talking about this case.
Oh, yes, yeah. And he doesn't make the decision. It's a supervisory decision that's made.
So you may have answered this. This is one of my questions. Do you believe that anybody who signed Exhibit 11, page 3, was intending to defraud the state of Michigan or the Bureau of Elections?
Yes.
Both?
The state of Michigan, yes. The Bureau of Elections, no, because it wasn't sent to the Bureau of Elections. There was no, I didn't find any evidence that it was sent to the Bureau. You're talking about the state of Michigan Bureau of Elections, right?
Correct.
Yeah.
But you have evidence that was intended to defraud the state of Michigan. How so, sir?
Well, it's representing the certificate of votes for the Republican Party for the state of Michigan. Just no different than the Democratic votes have been certified So. And that's not necessarily the best explanation, but I'm trying to put together my thoughts here. So it was intended to defraud the people of the state of Michigan just by sending an illegitimate slate of electors to the Capitol, to the National Archives, to the President of the US Senate.
So do you believe that all 16 signatures on Exhibit 11, page 3, was intending to defraud the state of Michigan by signing that document?
That's an answer.
The objection is asked and answered. You asked
I
them if
didn't
they
hear
were,
an answer.
excuse me?
I didn't, I asked this question a certain way, and I didn't hear him answer that question.
Was this any different from the first time he answered? Because I think his answer was he thought that they were trying to defraud, but not to the Bureau of Elections, because it wasn't sent there. So he did provide an answer.
I wasn't too sure if I said I qualified it with the 16 electors that were on that sheet.
That was
Correct.
the first question.
All right.
So how is this question different?
I did not think I quantified it as the 16 electors in the first question, Judge.
Oh, you
I
did.
apologize.
You did.
Yes, sir.
Okay, so you believe that those 16 electors intended to defraud the state of Michigan
Asked and
by
answered.
signing.
He's
I'm just
saying,
going over that, Judge.
we understand.
Thank you. Because you said yes, and I just wanted to make sure I understood exactly what you said. Thank you, sir.
I understand.
Are you saying that page 2 and 3 of Exhibit 11, those 2 pages, or just the 3rd page was intended to fraud?
The
State of
third page
Michigan.
is the signature page, is that correct?
Yes, Judge. Yes. I guess I am showing you my answer.
Just the, what did you say, the second and the third page?
Yes. Is it the combination of both pages, or is it just the 3rd page that that was signed shows an intention to defraud the state of Michigan? Or is it a combination of both pages?
Oh, it would be a combination
Right.
of all the pages.
Oh, of all the pages?
Well, except for the first page is just a memorandum.
So it'd be a combination of all the pages except for the first page?
Yeah.
So it'd be the 2nd, 3rd, and 4th, and 5th?
Yes, by signing it. Yes.
By signing it, you assume that those 16 electors, and then I'll ask you relative to Mr. King himself, did see page 2, page 4, and page 5, but you don't have any specific evidence that you did see those pages, correct?
Yes. It was,
You don't have specific evidence.
oh, correct.
Okay, you don't have any specific evidence that Mr. King saw those pages. Thank you, sir. Just got questions.
Yep. No problem. No.
Mr. Schock, you indicated in previous testimony that it was you believe through your investigation was Mr. Cheeseborough who created Exhibit 11, correct?
Along with, there was somebody else that I couldn't remember.
Correct, but it was none of the defendants in this room or part of this exam, correct?
Correct.
Okay, and it was also in your investigation, I just want to get this straight, did you indicate that was Mr. Cheeseborough who sent the document to the National Archives, correct?
No, that's
Did I
not
misunderstand that?
correct. Yeah.
Okay, who sent it to the National Archives?
Well, as I mentioned earlier, that we had evidence to suggest that Sean Flynn that mailed it off.
But none of the defendants in this particular exam here did it, correct?
That's correct.
You already testified to that.
Yes.
I just wanted to ask you another question. What part of Exhibit 11 can you point out to that defrauds the state of Michigan, knowing that there was no certificate of ascertainment with that document? How would that, if you couldn't, how would that defraud the state of Michigan?
Because it's designed to replicate the legitimate document.
And it's your testimony again, none of the defendants here designed that document, correct?
Yes,
Okay,
or correct.
so it's because this document looks like what? It looks
Are
like
you, is
what?
that a question?
Yes.
Okay.
It looks like what?
It looks like the certificate of votes.
Okay. From the Democratic Party is what you're telling me?
Yes,
Okay,
from the state of Michigan.
okay, because it looks similar.
Well, it looks similar in content.
And it looks dissimilar how?
Like I said earlier, graphics.
Graphics. And also that it does not have, when it went to the National Archives, are you okay?
Yes, excuse me.
All right, when it went to the National Archives and when it went to the federal court and the Senate, it did not have a certificate of ascertainment, isn't that correct, through your investigation?
Yes, sir.
No further questions at this time, Judge.
Your Honor, I hate to do this at 4 o'clock, but can I take a brief recess just to use the restroom?
It's been probably, we have not taken one since lunch, absolutely.
Thanks,
We'll
Judge.
do 5 to 1. Okay, you're still under oath,
Okay.
back on the record, and you can process it.
Yeah, Mr. Shock, I met you at the. Well, my client in this case, the county campaign. I would like to turn your affidavit, you charge these defendants with a conspiracy among the other charges. Right?
Yes.
In other words, that they conspired with one another, maybe with others that were uncharged.
Okay, back on the record.
Shock, part of your affidavit, and basically these charges, your belief that these individuals, the electors and others that were uncharged, conspired or agreed to work together to defraud the state of Michigan. That was your testimony across the board.
Yeah.
Okay. Now, through your investigation, you said on the record you interviewed Michigan GOP workers. Is that right?
Yes.
And by that you mean, I take it that you mean Laura Cox, Mike Ambrosini, Tony Zammit, Steve Foster, Troy Hudson, Henrietta Toe. Is there anyone, Stu Stanley, am I missing anyone else?
Yeah, Jeff Pfeiffer. I think that's it.
Now, are any of those individuals a part of this conspiracy? In other words, are any of them non-charged co-conspirators? If you'd like me to give them to you one by one, then I can.
Yeah, please do that, because I lost track of the names.
Absolutely. So let's start Michigan Republican Party Chair at the time, Laura Cox. Is she an uncharged co-conspirator?
Yes.
How about Mike Ambrosini?
No.
Troy Hudson?
No.
Stuart Foster?
No.
Stuart Sandler?
No.
Henrietta Toe?
No.
Jeff Pfeiffer?
No.
Did that cover it for the Michigan Republican Party?
So
And then you talked about interviewing Kenneth Chesbro. Who is he affiliated with? How did he become involved in this?
he was affiliated with the. Actually, he was an attorney out in Wisconsin, affiliated with the Republican Party up there, and then he became involved with the Trump campaign.
So he was working with the Trump campaign, but he's not really in the state of Michigan. So what's his conduit to the Michigan Republican Party in the state of Michigan?
He's the one, like I said earlier, that sent Marion. He sent an email out to Kathy Burden and Marion Sheridan. Marion Sheridan responded to me, so that would be, I believe, the conduit you're getting at.
Yeah. And then how about within the Trump campaign? Were there other folks here in Michigan who were working with directly? You discovered in your investigation? How about Sean Flynn, for example?
Yes, he was corresponding with Sean Flynn, John Black. Any other names? That's all I can recall right now.
Excuse me, Judge, just so we're clear, you're saying Sean Flynn was corresponding with John Black? It wasn't clear from the.
No, I'm sorry, it was corresponding with Ken Chesbro.
So Sean Flynn and John Black were corresponding with Chesbro.
Yes.
Thanks.
Yes.
Was there anyone else from Michigan Republican Party that was communicating with Kenneth Chesbro? Or was it really just Sean Flynn and John Black as far as you know?
Yes, as far as I know, and like I said, Marion Sheridan, that was it.
So then Kenneth Chesbro he's working with Sean Flynn and John Black. He's emailed Marion Sheridan and Kathy Burden, right?
Yes.
But how is he getting connected with the Michigan Republican Party if his documents are to show up at this meeting to be presented to people as you alleged in your affidavit? Reconcile that for us.
Yeah, through Marion Sheridan.
Through Marion Sheridan.
Yes.
Now, Was Kenneth Chesbro an uncharged co-conspirator in this case?
Yes,
And how about John Black?
yes,
And how about Sean Flynn?
yes.
Are there any other uncharged co-conspirators that those individuals from the Trump campaign were working with who were not located here in Michigan?
Yes.
And who are those individuals? Like, I can just get into. Okay, go ahead.
Mike Brown and Mike Roman, Gary Michael Brown, Mike Roman. That's all I can recall right now.
That's all you can recall right now. How about Rudy Giuliani?
What was the question again? Is he an unindicted co-conspirator?
Correct.
Yes,
Okay. How about Boris Epshteyn?
yes,
Judge, all right, James Trupis, a Wisconsin lawyer. That rings a bell?
yes, no,
All right, so those are there any other uncharged co-conspirators that we haven't talked about yet? Somebody talks more about the actual relationships. I just want to know who the players are involved. Is there anyone else that we're not thinking about or haven't discussed?
there was many names, but I don't recall.
Okay, so you don't really know or recall who else may be involved. There's certainly more than just the people we talked about. That's not really important to your investigation at this
Well, I think it's important, yes, but I just don't recall.
point. Okay. Did you conduct interviews with other people beyond that were uncharged, uncharged co-conspirators? I'm just trying to think if there's any other way to help.
So the only interview that we've conducted, the only person that's agreed to an interview was Ken Chesbro.
And so you learned from Ken Chesbro that there was a plan from the Trump campaign to produce this alternate slate elector, correct?
Yes,
And did you learn whether or not the Michigan Republican Party had the same plan or their own plan? Do you know?
yes, they had their own plan. Well, Laura Cox had described her own plan.
Okay. What did you learn from your investigation about why there were two different plans?
Laura Cox had a plan that she would call all of the electors to the GOP headquarters to celebrate their efforts for working for the campaign. And there was that document, which may be here. Yes, People's Exhibit 28 that she described. It was basically a contingent plan that describes a contingent plan.
And why did she have a separate document? Why was she not comfortable with, if you know, the document produced by Kenneth Chesbro?
I believe she indicated that she wasn't aware of that document.
And you don't have any email correspondence between her and Kenneth Chesbro or others from Trump campaign, probably, right?
That's correct.
Or, I'm sorry, to undermine that accounting. So you,
Yes,
yeah,
I did not find any evidence to suggest that.
okay. So there's no proof that the head of the Michigan Republican Party was coordinating with Kenneth Chesbro. That was just two individual electors and Sean Flynn and maybe John Black.
Yes,
And you understand from the investigation that the Michigan Republican Party's guidance from Laura Cox on down to the electors, not a part of the Michigan Republican Party, was that they were here for a celebration.
that's what she said.
And they did not know anything beyond that before December 14th, 2020, as far as you know.
For point of clarification, I'm asking, who is they?
And I'll just dial right in on Ken Vanderwood, Your Honor.
Ken Vanderwood, you said?
Yeah, so I'll rephrase the question. And so, well, what I'm getting at is you have two separate plans. You have the Trump campaign on the one hand, the Michigan Republican parties.
Yes.
We're talking about Michigan Republican parties. Laura Cox is the chair. She has explained this plan for a celebration. And prior to December 14th, 2020, do you have any evidence to show that Ken Vanderwood knew anything more than this proposed celebration was the purpose for that meeting?
The only evidence that I have was the statements from the GOP workers that said that they had called these folks to Lansing, called them to come to Lansing to sign a document. That's the only. Does that answer your question?
Sure, and let's just break that down. So were they told, as you understand from those interviews, that there was a celebration or that they were there to sign a document?
Again, who is they?
Let's focus on Ken Van.
Thank you.
So Ken Vander, was he informed that there was a celebration or that he was going to sign a document?
I don't know.
Okay. Let's take a moment and film the witness defense exhibit A. And we'll just see it. So, sure, that's defense exhibit A. Do you recognize that document?
Yes.
And you were just talking about prosecution exhibit 28. Is that a similar document? Is that how you recognize it?
Yes.
This is a document you discovered through the course of your investigation.
Yeah. Which one? 28. I just people
Yeah,
exhibit
we'll
20.
focus on defense exhibit A for now.
Yes.
All right. So defense exhibit A, I believe earlier you testified, I want to make sure this is correct. You did not learn that the document was signed until Kathy Burton was proffered in December of 2023.
Yes.
That's accurate.
Yes.
But you testified that you learned about the other document through Troy Hudson during his interview. Is that right?
That's correct.
Okay. Had you ever heard any reference of this document, signed or unsigned, before your interview with Troy Hudson?
Yes.
And how did you learn about it before that?
Through the interview with Laura Cox.
Okay, so tell us about that. Did Laura Cox give the documents to the Attorney General's office in that interview?
I don't recall. I remember there was an interview with Laura Cox prior to me taking the case. So
And who conducted that interview?
I want to say it was, well, from our team, it was Agent Cronin, I believe Agent Steckel, Mike Steckel.
I'm sorry, jumped in.
I don't know who else was
Okay.
involved. I don't remember.
Do you have a rough timeline of when that would have been?
Fall of 2022.
Okay. So sometime in the fall of 2022, you learned that the unsigned or signed document, that this Michigan Republican Party version exists.
Yes.
And then you didn't find out that it was signed or that a signed version exists until December of 2023.
So I learned about her plan from the interview that was done earlier. And then I learned of the document when I interviewed Troy Hudson. That there was an actual document and that his attorney later produced. That
I'm a little confused. Did Laura Cox provide the documents to the Attorney General's office?
I don't recall.
You don't recall?
Yeah.
Okay. So you might, the Attorney General's office might have had it before your interview with Troy Hudson. You don't know. Or
Yes, I don't know.
but you certainly learned about it from Troy Hudson. You said it was a signed copy, and then you asked his attorney to provide it. And that's how you got to see the document.
Yes.
Is that the first time that you saw the document that you recall?
Yes.
Yeah, I mean, just for purposes of the record, can we use exhibit number so we know which document we're talking about?
That's fair.
Thank you.
And so, Your Honor, I'm at, and for the record, I'm referring to both Defense Exhibit 2 and Prosecution Exhibit 28. Which is Defense Exhibit A. I don't know what.
Defense exhibit A.
So those two exhibits, the prosecution being an unsigned version, the defense is a signed version. That is what the subject of this testimony has been since I handed the document. So that's when you got the document from Troy Hudson. When did you learn that the document was signed after?
I don't know if I learned that it was signed at the meeting. I learned that it was signed. So that would have been December of, I'm guessing it was sometime December of 2022. 3.
Did you ask Troy Hudson, his attorney, to provide a signed copy of that document? You remember?
I don't remember that.
If you saw the email correspondence with the attorney, that help refresh your recollection.
Yes, if you have it.
I'm not looking at this. I mean, the witness, email correspondence between me and the attorney for Troy Hudson, Mr. Eric Doctor. Give you a second to review that, sir.
Yes.
And are you
Mike,
done?
when's it
with that?
dated?
What's that?
When's it dated?
I can. Dated March 6, 2023, an email from myself to Mr. Eric Doster regarding Troy Hudson, asking to provide a copy of the document that was signed in the basement.
So Troy Hudson, I assume then must have told you the document was signed in the basement that day. Is that correct?
I would have to assume, again, I would have to go back to my report or interview with Troy Hudson, that report.
I believe you previously testified that in response to that email, his attorney sent you the unsigned version for prosecution exhibit 28. Is that correct?
Yes, sir.
If you were asking for the signed document and he didn't give it to you, what is defense exhibit A? What were the steps that you took between then and December of 2023 to try to find the signed document and or confirm if it was actually signed in the basement that day?
I believe I went back to the attorney, but again, I don't recall. I would have went, if he produced the document that wasn't signed and I'm asking for a signed one, then I would have went back to him and said, hey, what happened? I thought there was a signed one.
Did you do
So
that?
again, I don't recall. If there's not an email, then it would have been a phone call because we corresponded through phone and email.
What other steps did you take to try to find the signed copy of that document or to confirm whether or not it was signed in the basement?
I tried to identify the email account for Troy Hudson to obtain those documents, but I wasn't able to locate them through that. So typically we would identify an email, do a search warrant, go about it that way, and I was never able to do that. And
Now-
again, it goes back to 2 years after the fact, and there's a change of personnel and staff and email and everything else. I even tried to look at the expenses that were reported to identify, you know, what email server they were using, host, I should say, email host that they were using at the time.
Now, in your interviews with these witnesses, did you show any of them prosecution exhibit 11, the actual alternate slate that was already signed in this case?
I don't recall.
Did you ever show any of them defense exhibit A during any of those interviews?
I don't believe so. I would have, I think I had a couple interviews done before I even had knowledge of this, or a few interviews done before I even had knowledge of this.
Now, but you did give Mr. Renner at least the opportunity to address prosecution exhibit 11, right, and answer questions about it.
Yes,
The alternate slate. Not defense exhibit 2 or prosecution exhibit 28.
okay, 28, yes.
Not 20, I'm talking about prosecution exhibit 11. The actual alternate slate. That's
Yes,
the document you asked
Yes,
about. You
yes.
never showed in the unsigned or signed version of the Michigan Republican Party document. Defense exhibit A or prosecution exhibit 28.
I don't recall that.
And so you didn't ask any witnesses before you charged this case and swore out your affidavit whether or not they ever saw or were aware of defense exhibit A or prosecution exhibit 28.
I did ask if there was, if this was to be a celebration. I did ask those witnesses that if there was something along the lines that Laura Cox had said that this was to be a celebration. And then she or Stu Sandler had created this document. Document is People's Exhibit 28 or Defense Exhibit A. I did ask those questions.
I understand that, but you didn't show them that document. You only showed at best prosecutions in 11 to at least Mr. Renner to explain what they may or may not have signed that day.
Yeah, I don't recall.
And these interviews happened several years after the fact. Did you have any concerns that maybe they should see both documents?
When you're saying both documents, you're talking about People's Exhibit 28 and 11, right?
Correct.
Okay. It all depended upon the line of questioning, and I don't have any concerns. If I had a concern, I suppose I would have acted on that concern.
If this had been, if Laura Cox's version of events were true, and there was nothing more than to be a celebration on that day, and they were just to come in and memorialize those votes, would that have impacted your decision to charge all or some of these defendants in this case?
Yeah, could you repeat that? I don't understand what you're asking.
If the only document that had been signed that day, how about a different question?
Okay.
The only document that they had signed that day was Defense Exhibit A, the same as Prosecution Exhibit 28. That were the only document they signed, and prosecutions of them didn't exist. Would you have charged or swore out your affidavit against these, some or all of these collectors?
People are asking for clarification as to that.
In this case, all 16 of the electors.
No, because there's only one signature line there for Kathy Burden, and then there's a notary. That's it. So none of the folks or none of the individuals are listed on this document. And this is a contingent document. It says in the language.
Well, that's where I'm getting at, is that you've heard testimony earlier today from Mr. Renner. One of the purposes was that this was a contingency plan. I believe he said Plan B. You remember that?
Yeah.
And this document, Defense Exhibit A and Prosecution Exhibit 28, is consistent with that description of a Plan B or a contingency plan.
Yes, but he wasn't talking about that. He was talking about People's Exhibit 11.
Oh, no, I'm asking you, sir.
Oh.
Are those two exhibits, not 11, but 28 and Defense Exhibit A, are those consistent with his testimony that they were there
A contingency?
Yeah, a contingency.
This is yes, as I stated before, this is a contingent document. Or at least that's what the language describes it as.
And there's been testimony, and it came out with Mr. Renner today. I can't remember, honestly, if you were asked, so I forgive me, but it seems to be unclear. You still do not know if any of Prosecution 11's pages were stapled together or presented to the individual electors in one full document altogether, correct?
No, I mean, Mr. Renner had testified that they were together, pages 2 and 3, and then that also was the same thing we heard from Tony Zammit, where there was multiple pages of a document on the table. So does that answer your question?
And Mr. Zammit wasn't sure what those pages were, right?
Yes.
And Mr. Renner described as there were some documents spread across the table, and he wasn't sure if all of them, but at least he remembered pages 2 and 3 of Prosecution Exhibit 11. But that's how many pages? 11-page document, I believe. It's more than 2 pages, right?
People's Exhibit 11.
People's Exhibit
I
11.
think it's 5 or 6. 5. It's more than 2 pages. Yeah, it's what do I have? 3, 4, 5. Yeah, you were close to right. 10. I think it's 10. Nine. I'm sorry. He was counting.
Clearly, I did too. Thank you for helping us clarify. But you didn't think it was important to ask those witnesses, Michigan GOP or anyone else, whether or not both of those documents, Defense Exhibit A and Prosecution Exhibit 11, were both present and meeting next year?
No, we didn't.
You did.
I said that. I said, depending upon when I came in to this document, People's Exhibit 28 from Troy Hudson, I had asked them, was there another document? I believe I had asked the GOP workers if there was another document down there. You know, but the sequence of events, we started the interviews, and I don't know where Troy Hudson fell into that sequence. So after we learned of that, then we started talking about it. But at the time when I was started the interviews, I just was aware of this document, People's Exhibit 11.
All right, so moving on from the documents, I'm sure everyone can read. The essence of this is that there were two separate plans and two separate documents, one from the Trump campaign and one from the Michigan Republican Party.
Yeah.
Regardless of the legality or authority to follow through on any of those plans, the only piece of evidence that you have to connect Kent Vanderwood to all the other folks who conspired before those two plans and two documents is essentially page 3 of prosecution exhibit 11, because that's where the signature before it appears, correct?
You lost me there.
You don't have a document, email, text message, social media post, a phone call, or anything else to suggest that Kent Vanderwood knew or had knowledge of what he was signing reportedly if he signed that third page of prosecution.
No, I don't.
You heard Mr. Renner testify today, cooperating witness, that he did not personally see or observe him do that.
Yes,
And he didn't have any conversations with him to corroborate whether or not he ever even saw the document, let alone read it, agree that that's what he was signing.
yes,
And your assumption, I believe, was that Kent Vanderwood should have known because of his experience, his professional experience. Is that right?
yes.
Okay. So just as you did for Mr. Brock, could you please explain then what in Mr. Vanderwood's background caused you to make that assumption?
He's the mayor of Wyoming. He's been through elections.
Has he been through a presidential election?
No, you cut me off, but he has a limited, I guess, experience as a candidate. He became mayor, right? But he hasn't been a state senator that I'm aware of, or a congressman or anything like that.
So the signature appearing on page 3 of prosecution exhibit 11, and the fact that he was the mayor of Wyoming, Michigan, and had some experience in politics. Is that fair?
No, I mean, so going back to Mr. Renner's testimony, I mean, we learned that Mr. Vanderwood was there on this date. It was explained to them what they were doing. So I would include that as well. I mean, it was explained to them why they were there, what they were doing, what they were going to sign.
So I recall that from Mr. Renner's testimony. My recollection is that he testified today that he learned those purposes after he signed the document.
Yes.
That document being page 3 of prosecution exhibit 11.
Yes.
So beyond that, you don't know that Kent Vanderwood knew before he allegedly signed that same document any of the purposes for it or any reasons why you're here for a celebration.
No, I think it goes back to the fact that he was at the GOP headquarters on this date and time. As Mr. Renner testified to, whether he knew it just before he signed the document, just after he signed the document, it was explained to him what was happening. I never learned or had any evidence to show that after they heard this, there was, there was some sort of opposition and they tried to pull back the document or made any effort to do that.
Well, you did hear that Mr. Renner went to the Capitol, but as far as we know, Mr. Vanderwood did not, right?
Yes, that's correct.
That's consistent with your investigation. You did not identify any videos going to the Capitol earlier.
No.
And you have You heard from Mr. Renner that he identified two purposes of the meeting that he learned after he signed. One was to take it to the state legislature here in Lansing.
Yeah.
And the other was to create a document in case of plan B or a contingency.
Somewhat, yeah.
And he testified that he had no knowledge that this was going to be sent anywhere else, to any entity in Washington DC, for example, right?
Yes, he did.
And you don't independently have any other evidence to show that Kent Vanderwood knew that this document was going to be mailed to Washington DC.
No.
And you know that he did not go to the Capitol with the rest of the electors.
Yes, that's correct.
So the only thing is your assumption that because he was the mayor and had some experience in politics, his signature purportedly appears on page 3 prosecutions of the letter. There that on December 14th.
Yes, and he was a part of the meeting or listened to what they had to say, so
So you don't know precisely what they had to say, do you?
just according to what Mr. Renner said, also, I've done interviews with Michelle Lundgren, Rose Rook. So, taking all that into consideration.
Right, and taking all that into consideration, every single one of those witnesses reiterated that this was for a celebration, for a ceremony. That's why they were asked to go there. Right?
No, they didn't say that. They weren't there for necessarily a celebration or a ceremony. Not everyone said that. They were there to sign a document. That's what they knew. That's what I learned.
You have any documented evidence that's going to show that Kent Vanderbilt knew that you were there to sign the document before you arrived in Michigan Public Party?
No.
May I have one moment, Your Honor?
Take it in.
All right, especially Mr. Doc, I want to come back to Kenneth Chesbro and what you learned about his plan. So Laura Cox said that this was for a ceremony. What did Kenneth Chesbro lay out for you?
He laid out putting together a second slate of electors. At first, it started out, again, this is a plan that's not just isolated to Ken Chesbro, so there's more people involved here, but he laid out the plan was putting together a second set of electors in 7 states that the Trump campaign believed that there was election fraud or the election may be contested. Initially, it was put together in hopes of a court ruling in their favor, and then when that didn't happen, then the plan B was to present it to Vice President Pence with the hopes that he would stop the count and not be able to determine which is the legitimate slate, and then it would go to Congress for debate.
When did you meet with Kenneth Chesbro and learn that plan?
December of 2023.
And you swore your affidavit for the charge in this case in July of 2020.
Yes, sir.
Anything with Kenneth Chesbro change your impact in the statements you heard that day?
No.
So you were asked about this paragraph of the affidavit previously, paragraph 27, where you stated that the candidates for elector in Michigan Field leadership knew prior to their meeting on December 14, 2020, that there was no legal reason to create an alternate slate of electors. Do you remember that?
Yeah.
And then you met with Kenneth Chesbro in December, and he laid out for you, in his opinion, as a lawyer, what the legal reason was to create an alternate slate of electors. Is that a yes or no?
Your Honor, that's a mischaracterization of the witness's testimony. That was the initial plan that evolved when the legal realm failed, which was what the witness's testimony box.
Well, I think I need to be able to understand where it evolved from. Your Honor.
You say you didn't understand where it evolved from?
Yeah, I think that we need to get into the plan and ask how it did evolve over time. That's what we're.
I don't know that that's her concern. I think the concern was the characterization of the way you characterize his previous testimony. Yeah. To the exhibit. But he knows exactly what portions you believe is mischaracterized.
Yeah, because I read from the affidavit and then I asked him, he just explained that with Ken Chesbro and he explained to you the alternate slate of electors plan.
Council could just ask how did the plan evolve, even though I
It's
believe,
cross-examination.
Council can ask what?
how the plan evolved, although I believe that was also answered in the witness's question when he talked about Kenneth Chesbro's plan, how it was first supposed to be a contingent relying upon the courts to rule in their favor. And when that did not work, then it became getting it to Vice President Pence so that he could either stop the vote and open it up for debate. That was the witness's answer to what Ken Chesbro's plan was.
Then you wanted to take it further as to,
My question, Your Honor, is this is what your affidavit says, and that was before you met Ken Chesbro, and then he provided you, in his opinion, his legal theory. to
Okay.
justify the plan.
It's not the question I just.
well, maybe he didn't ask it the best way and he's rephrasing.
So Mr. Shaw, you understand what paragraph 27 of your affidavit says? Essentially, they had no legal justification. That's not what. Yeah, please, you know, I know that you know.
Right, we need a yes or no, but I also need you to keep your voice up because I'm struggling to hear you because you're way over there.
I apologize.
No problem.
Won't make that mistake 3 times.
And this glass stops your voice.
So, okay, Mr. Shaw, Ken Chesbro explained that plan to you, correct?
Yes,
That in his opinion, as a lawyer, you could present an alternate slate or create an alternate slate of electors, correct?
yes.
And then what changed, I guess? That's, I think, something that we mentioned. How did that evolve from there?
I don't know what you're, what changed for what?
So he said that there was a legal reason to create an alternate slate of electors. You say that there wasn't. How did he justify that?
So, as I mentioned earlier, when I said there wasn't a legal reason, I was referring to there was no court order directing them. There was nothing from the state. There was no recount. So Ken Chesbro was basically arguing a reason why he believed that there was. I don't recall the specifics on, what his logic or reasoning was. And I remember him talking about the Electoral Count Act and, constitutionality of it. I don't remember like the legal reasoning or justification. It was a long interview. There was a lot of information that was provided. So I don't recall like his justification for all of them. And when I brought up to him, Michigan there was a vote difference of 150,000 votes. And there wasn't a recount here. I don't remember what he said to that.
Were you ever able to disprove his legal justification and his legal theory for this alternate slate of electors?
I don't think I've worked on trying to disprove his theories.
So I guess you don't know if that legal theory is legitimate or not.
Yes, that's correct.
How then are you certain that the electors, the 16 of them, did not rely on that legal advice or legal theory when they met in the Capitol on December 14th, 2020?
Well, I didn't have any information to show that Ken Chesbro explained his legal theories to the group of electors.
You have that now?
No,
You don't know that anyone explained what the purpose of the alternate slate of electors was?
I know that Mr. Renner had testified to the fact that I think it was the ones that were driving the meeting or conducting the meeting were Ms. Burden, Rodriguez, and Maddock, but I don't to answer your question, I don't have any information to show that Ken Chesbro laid out his legal theory to any of these individuals in a group or individually, I should say. In fact, I don't have anything to show that any of them were relying on a specific theory or a reason or, a specific court case that said, we need to do this because the judge in this case is going to rule B or A, he's going to reveal this information.
So you don't know if any of that was discussed in the basement or elsewhere at the Michigan Republican Party headquarters, right?
Correct.
And you don't have any documents connecting Kenneth Chesbro to these people explaining that plan.
When you say these
To the
people,
electors,
just,
well, outside of the two that you had already previously mentioned.
yes, that's correct.
Did Mr. Chesbro provide you with any documents to corroborate his legal theory that supported the alternate slate of electors plan?
I believe he did.
Do you remember what those things would have been?
I remember he sent there was a paper or an article published called maybe the Lessing Report.
Lawrence Lessig, is that name?
Yep, I remember that.
Did you review that?
I did at the time. Yeah, I don't recall what all the specifics are on it. There was some other documents or emails that he provided where he talks about his theory and basically communicating that. I think initially it started out with conversation through email between him and Judge Trubus.
Could you explain?
Oh, Judge Trubus was former judge in Wisconsin. He wrote an attorney.
Okay, so one of the paragraphs of your affidavit in support of your complaint says that the candidates knew prior to their meeting on December 14th, there was no legal reason to create an alternate slate. And Kenneth Chesbro has put forth a plan for you that is a legal reason to do so. What other steps did you take to prove or disprove that there was a legal justification to do what they did?
Well, as I had mentioned, the reason why I put there was no legal reason is because it wasn't. What I meant by that is that there was no court ordering the Republican electors to meet. There was no recount. There was nothing from the state legislature summoning them to Lansing to vote. That's what I meant by that. So there was a lot of legal theories and court cases and stuff like that, but I didn't work to disprove. I don't recall working to disprove any of Mr. Chesbro's theories.
So you cannot disprove those theories.
I don't believe I tried. I don't recall trying to disprove his theories.
Your client disappeared off Zoom about 2 minutes ago. I'm not sure if he's planning to log back in. Thank you.
Thank you. If someone, he's an uncharged co-conspirator, correct?
Yes.
Did you consider charging him at one point?
I don't consider charging anybody. That's a decision that our assistant attorney general made.
Well, you swore out this affidavit. He's not one of the defendants that resulted from it, correct?
That's correct.
And so if a co-conspirator, as part of an investigation, presents some kind of a defense, you would typically investigate that, wouldn't you?
Yeah.
And your testimony today is that you did not do that with regards to Kenneth Chesbro's plan.
That's not true. No, I did investigate us, again, looking at all the material and information. I did search warrants on his social media accounts to show what he knew at the time. So what I didn't do, and I said that I didn't try to disprove his legal theories. I think that would almost take a law degree to disprove a theory. I mean, I can try and verify something is accurate or truthful, but I think my interpretation of what you're asking as far as me disproving a theory would take a law degree to.
Because just like my client Kent Vanderbilt, you don't have a law degree. You were unable to ascertain or discern whether or not that legal theory was proper.
Yes, I was not able to determine his legal theories that are improper.
And you have no clue whether or not that legal theory from Kent Chesbrough trickled down to Kent Vanderwood and some of the other electors, do you?
I don't know that.
We talked about some of the uncharged co-conspirators, and it starts with really, there's the Trump campaign is pushing for this plan, right?
Yes,
Right, and then they involve the Michigan Republican Party to actually have this meeting and bring the electors in.
yes,
The Michigan Republican Party tells the electors that it is a celebration and a ceremony.
yes,
And when you say the Trump campaign had initiated this idea, I mean, that starts with Donald Trump, right? He's also an uncharged co-conspirator.
yes,
And then all the way at the other end of that spectrum, so you've got Donald Trump down to Boris Epstein, Rudy Giuliani, Kenneth Chesbrough, John Black and others, Sean Flynn, all the Michigan Republican Party individuals, including the chair of the Michigan Republican Party. And then somewhere at the end of that list are the 16 electors. Is that a fair description of the hierarchy of this conspiracy?
yes,
And within those electors, it would appear from your testimony and others that there's different levels of involvement from each of those 16 electors. Is that correct?
yes,
Some people were connected with Kenneth Chesbrough in advance, right?
yes.
Kent Vanderwood is not one of those individuals.
Is that a question? Right, correct.
Correct. Kent Vanderwood is not one of those individuals. Some of the individuals, like James Renner, went to the Capitol to deliver the alternate slate to the state legislature. Right?
Correct,
Kent Vanderwood is not one of those individuals.
correct.
You testified earlier that you have evidence to suggest that Sean Flynn mailed the document to Washington, D.C., right?
Yes,
By evidence to suggest, that means that you don't know with absolute certainty whether or not it was Sean Flynn.
yes, that's correct.
It could have been someone else,
That's correct.
but you have no evidence to show that Kent Vanderwood mailed the document to Washington, D.C.
That's correct.
And you heard Mr. Renner testify earlier that he never saw the cover page, the first page of prosecution exhibit 11, right? You recall it's the memorandum from Captain Burden with the address in Washington, D.C.
Yes, sir.
And Mr. Renner doesn't recall seeing that document, right?
Yes, that's correct.
And he testified that he doesn't remember seeing it or otherwise knowing that the documents were going to be sent to Washington, D.C. Right?
Yes,
And just like Mr. Renner, you have no proof that Mr. Vanderwood knew that the documents were going to be mailed to D.C. by anyone, correct?
yes,
Because we don't even know who did that, right?
with 100% certainty, correct.
We just know it wasn't Kent Vanderwood.
Yes,
And there were alterations made to the document in prosecution exhibit 11 that Kenneth Chesbrough drafted, right?
yes,
But we don't know who made those alterations.
no,
The only evidence that Kent Vanderwood had any intent to commit these crimes, they require specific intent, correct?
yes,
The only evidence of that is your assumption that he must have known something because he was a mayor. Fair?
no, I mean, he was at the meeting.
And I'll get to that. I'm talking about that one issue. Your assumption
Okay.
about him being the mayor, equating to specific intent. That's part of it, right?
No, I'm equating the mayor to election law and process.
You've learned a lot about the election process now. You know that electors, federal, presidential electors are not involved in the mayoral election out in Wyoming, Michigan, right?
Yes.
You don't actually know that he's ever learned anything about the electoral process.
No, I said election, the election process.
So just general election knowledge, that's an assumption. based
Yeah,
on his
it's based on
role.
him, yeah, winning the election.
Okay, I'm just clarifying. Okay, the next part is that he was at the meeting, and they have the photo of the group there, so that's the second prong here, having some support specific intent, correct?
Yes,
And the third thing is that his signature appears allegedly on page 3 of prosecution.
yes. And then he was called there by, I think he was called there by Stu Foster.
So he was called and asked to be there by the Michigan Republican Party.
Yes,
He did not go there on his own volition.
right,
There's no evidence he was going to go to the Capitol for any reason, but for the fact the Michigan Republican Party asked him to do so.
Yes.
The Michigan Republican Party did that because the Trump campaign asked them to do so.
I think it was a combination of the Trump campaign and the Michigan GOP.
So
They were both kind of agreeing on that.
Right, I mean, we've heard testimony, they worked in tandem frequently, right?
Yes,
Ken Vanderwood did not work in tandem with either of those entities or those individuals to create these documents, draft these documents, send these documents anywhere, or otherwise do anything those documents did.
well, he worked with them to sign the document.
Maybe,
Right.
no one's
But-
seen him sign the document, right?
Correct.
Objection argumentative.
The question was, I mean, the objection was no one seen him to your question. Should no one seen him sign the documents, right?
Well, and that may be part too.
I don't think I heard the maybe part.
I heard
Oh, okay. I didn't hear the maybe part. What was the maybe part two?
it was right before he said nobody's seen him sign the document.
Oh, okay. Well,
That's why I
that's
objected.
to the statement of maybe. I didn't hear that, but I guess I'll grant the objection if that's what you said.
Okay, can I rephrase without maybe?
Yes.
Sir? So my point is, we had the two plans, the Michigan Republican Party, the Trump campaign led by Donald Trump. Mr. Vanderwood was not a part of those plans, right? We have December 14th, 2020, before his signature appears on anything.
Yes, sir.
He is not a part of any of that plan. That's Kenneth Chesbro, other uncharged co-conspirators, maybe some of the other records, but not Kenneth.
Right.
And you don't have anyone who's going to testify to say, I saw him sign that document.
Correct.
And that is the linchpin, right? That is the thread that holds Kent Vanderwood all the way to Donald Trump and all these other people who planned this, is that his signature allegedly appears on a document that you don't have anyone to say he saw or reviewed it, right?
Yes,
You don't have anyone to say, I saw him sign it, right?
that's correct.
And you don't have anyone who's gonna say he went to the Capitol, right?
That's correct.
And there is no one that's going to say that he mailed this to DC or was aware of that plan, correct?
That's correct.
One moment, Your Honor. I don't have any questions. Thank you. Thank you, Mr. Shaw.
Redirect.
It's gonna be a while.
It's gonna be what?
It's gonna be a while.
Okay, we can do it tomorrow then, as it's 5. Okay. So we'll adjourn for today. Tomorrow we'll begin with the redirect of Agent Shock, and then what witnesses do we have tomorrow?
That's my final witness.
Okay. Is the defense gonna be calling witnesses?
No, Judge. Judge, if I may, when you say it's gonna be, how long is it?
It's only take as long as it needs to take.
Well,
I've
no,
got three crosses that I need to address.
I get that. If we could do it now, I think we'd all rather just do it now. The court's
I
implementing.
don't.
I'm not
wanna rush.
inclined. Because we're carrying, we keep not just the people in this courtroom open, we keep the security here. So it's 5:03, we'll adjourn for today. And we convene tomorrow, 4 o'clock. Or redirect, I'm sorry. And then I'm sure whatever further questions her redirect prompts that you all will need to address. So at this rate, or at this time, the defense is not expected to call witnesses?
That's correct. That's correct. Your Honor.
That's correct.
Okay, sounds good. Okay, so we'll complete agent talk tomorrow and then conclude this iteration of exam. Tomorrow at 9 a.m.